Guys? The Honorable Chief Justice and Associate Justices of the United States of America. Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw nigh and give their attention, for court is now sitting. God save the United States and this honorable court. You may be seated.
Well, we have before us the case of the United States versus Alvarez and Madeline Suchard for the petitioner. And you're going to have to instruct me on how to pronounce your name.
McCurchin, David McCurchin.
David McCurchin for the respondent. And we will proceed with oral argument, beginning with Ms. Suchard.
Your Honors, before I begin, I ask that I am able to reserve 2 minutes for rebuttal.
Yes.
Thank you. May it please the Court, my name is Madeline Suchard for the petitioner of the United States government. Man is the only creature who is willing to die for an idea. When a person is willing to sacrifice their life, their time, their ability in order to defend an idea, not just to defend their friends and family, but to defend an idea of an American society, a society where there's liberty, where there's equality, where there's opportunity. They've given a great sacrifice, and when someone is falsely representing themselves as having not only served in the United States Armed Forces, but having been recognized as having been honored by Congress with either the Purple Heart or the Congressional Medal of Honor, it is a disrespect, not just to the military itself, but to those individual people, these citizens, who are giving up their time. Now, what the Stolen Valor Act of 2005 is doing is making it a crime to falsely represent oneself as one of these people, someone who has been awarded this congressional decoration. And the speech that is being prescribed with this act is speech that has already been deemed by precedent to not have constitutional protections. In Chaplinsky versus the state of New Hampshire, it was established that speech that is among the lewd and obscene, the profane, the libelous, the insulting or fighting words by which their very utterance tend to inflict injury or incite immediate breach of the peace.
Ms. Suchard, if I say I won the Congressional Medal of Honor, are you going to hit me?
Well, no, Your Honor. No, Your Honor. I would not hit you for saying I won the Congressional Medal of Honor. It doesn't necessarily have to be physical injury. It is injury to the medals themselves, their prestige, as well as to the reputation of the armed forces. It serves as defaming statements.
But it's not fighting words in the Chaplinsky sense.
No, Your Honor. I believe it's more in accordance with libelous or insulting words.
All right.
These words, these insulting, these libelous words, have such little room in the exposition of ideas, and the societal value clearly outweighs them, as these words have such slight value. There's a compelling government interest.
Well, but counsel, don't libelous words usually attack a third party? What third party is being criticized by this speech?
Well, Your Honor, it isn't necessarily any direct criticism to a certain individual. What it is a criticism that goes beyond that and to all the individuals who have been awarded this honor. For instance, when Mr. Alvarez says, I won the Congressional Medal of Honor, he is not directly attacking, he is not saying the Medal of Honor is horrible, but what he is doing is casting lasting damage upon not only the prestige of these medals, but the reputation of the men and women who have earned them.
Counsel, I'm a little troubled by this idea of defaming or libeling the military. If I stand up in front of, say, the White House, and I say something like, there were 1 million people murdered, innocent people murdered by the US military last year, and let's say I know that statement is untrue, but I say it. Under your definition, may the government prohibit or criminalize my statement?
No, Your Honor, they wouldn't be able to criminalize it. The government has set this precedent where political speech and artistic speech is highly prized, and in the context of this protest, you would still merit constitutional protections. You would have that breathing space as established by New York versus Sullivan. What we are asking is that a false representation, in the case of Gertz versus Welsh, has already established that false representations of fact do not merit constitutional protections. It is only that speech that is this false reputation, that is causing this irreparable damage. The truth rarely catches up with a lie. When someone lies about being given this highest honor, even if there's a retraction, even if there's an apology, there's still going to be damage there, this lasting damage.
Tell me more about Gertz.
Well, Your Honor, in this case, it was regarding defamation of private individuals. However, the court also stated that defamation as a class of speech falls within the unprotected category deemed as false statements of fact. They have this precedent where if false statements of fact have this little societal value going in accordance with the precedent established in Chaplinsky, that when there is this such slight societal value, when there's compelling government interest which counteracts it, when there's no room for it in the exposition of ideas, this speech cannot be allowed. It is causing this damage.
So you're urging on this court a balancing standard in which the free speech interest is balanced against the government's interest in protecting the reputation of the award. Do I have you correctly on that?
Yes, Chief Justice.
Thank you.
Furthermore, Your Honor, the standard that should be applied to this law should not be strict scrutiny. It should be the breathing space standard established under New York Times versus Sullivan. In the cases of Chaplinsky and Gertz, the court was able to prescribe speech without using strict scrutiny. Strict scrutiny only needs to be applied when speech that already merits protections is being prescribed.
Excuse me, counsel. If we were to apply strict scrutiny here, do you concede that the law would be unconstitutional?
Well, Your Honor, if you were to apply strict scrutiny, I do not believe that the law would be unconstitutional. For it to surpass strict scrutiny, this high standard, one, it would have to be speech that has First Amendment protections. This speech being prescribed clearly doesn't have this, but furthermore, we have this compelling government interest in preserving not only the dignity of the military, but the individual servicemen and women, these private citizens. Furthermore, the law is narrowly tailored. It makes it a crime to falsely represent oneself. It is established, and it's not necessarily a bright line rule. You can take it on a contextual basis as you would any case. A person who is falsely representing themselves in a movie or for political speech will still have those protections. We respect the breathing room established by New York Times versus Sullivan. But if it were to come to that, if you were to apply strict scrutiny, this law would be able to survive it.
Counsel, how do we tell? How do we tell what counts as a statement that has breathing room and what doesn't? So you've described a couple of examples. I asked about the protest earlier, and you said that would be protected. You used the example of a movie, and you said that would be protected. Yet, obviously, you think that the defendant here is not protected. Where is the line?
Well, Your Honor, as I said before, there is no bright line, but it would have to go based off the precedent this court has already shown. If it's done merely for artistic and political purposes, the court has ruled many times, such as in Texas versus Johnson, Cohen versus California, that speech does have protections. It would have to be taken in the sense that it is being done, it is causing this disparaging effect due to the fact that this person is acting with a knowing disregard of the truth, falsely representing themselves in order to merit the benefits and the goodwill given to so many people who have been awarded these medals. Your Honor, in New York Times versus Sullivan, it stated that knowingly false statements and false statements made with reckless disregard of the truth are unprotected. A person who is going about saying that they've won these medals has a knowing disregard of the truth. This isn't something that they can get confused on. There's this government interest. The government obviously has a clear social interest adhering to the precedent assured in Chaplinsky. It seeks as a whole to preserve the prestige of military honors, not just so that the awards themselves don't suffer a diminished value, but also for the benefit of servicemen and women, past and present.
But what if there's an easier way to preserve the prestige of these medals? For example, publishing the names of people who won them. That way you would protect the prestige. People would know that other people claiming they had won the medals hadn't. And you also wouldn't have this intrusive criminal statute. Wouldn't that indicate that this law isn't as narrowly tailored as it needs to be to meet strict scrutiny?
Well, I disagree, Your Honor. Even if there was this list published, how many people in the general public would be aware as to who has and who has not won this award? A person with reason, a person could say, I won the Congressional Medal of Honor, and if another person believes him and finds out later they're a liar, there's still going to be that disparaging effect. The truth, even if finding out that, oh, this person did not win, there's still going to be that lasting damage, this irreparable damage to the awards and the people themselves.
We're infringing on your time, but I want to follow up on this point. Today, in the age of the internet, I can find out in about 30 seconds whether someone has won a Congressional Medal of Honor. So why do we need a statute?
Well, Your Honor, would you be looking before the person in question has made these statements?
No, as soon as he's made the statement, I can find out immediately whether he's won it or not. And if he's lying, he's damaging himself. So that in that sense, the reputation of the medal is self-reinforcing. It doesn't need a statute.
Well, to you, Your Honor, he might have only damaged himself. But to any lay person, if they see these aspersions with someone associating this high honor with a liar, that damage is irreversible. The truth rarely catches up with a lie. Even if we know the truth, the damage from the lie is still there, and we're not able to escape it. Your Honor, I ask that you find that the Stolen Valor Act of 2005 is constitutional. Thank you.